We will be getting started in just a moment as folks join us. So just hang tight and give us a couple seconds as folks join us. We will begin starting momentarily. Hello and welcome, everyone. It looks like a number of you have already joined us, and I know a few more will still be, but I want to go ahead and get us started and just say welcome. My name is Allison Carrel, and on behalf of my co-director, Lynn Cohn, and all the faculty and staff at the Center on Negotiation and Mediation at Northwestern University Pritzker School of Law, those are a bunch of long names, I couldn't be more excited to welcome you to this exciting interview series that celebrates the publication of a unique new book, Discussions in Dispute Resolution, the Foundational Articles. With me today, and who you'll see in just a moment, are the three editors of the book, Professors Art Hinshaw, Andrea Schneider, and Sarah Cole, as well as the author of this week's featured article, Professor Carrie Menkel-Meadow. Now, before we get started, I'd like to take a moment to orient you to some features on the Zoom webinar to ensure you can take advantage of all that it has to offer. So I want to start by just mentioning we are recording today's webinar, but for your privacy, all the attendees have their audio and video currently muted. We also have both the Q&A functions as well as the chat functions turned on. And you might ask, well, why both? And the reason why both is because we want to give you sort of an option as to how we're communicating with each other. So one way to think of the difference between the two functions is that the Q&A is really more for the formal questions to Professor Menkel-Meadow that Professor Sarah Cole is going to be moderating during our Q&A section at the end. While the chat function is a little more informal. So for instance, go ahead and click on chat and let us know where you're zooming in from, because based on the registration, I think we've got folks from all across the country and maybe even across the world. So click on that little chat bubble and share with us. As folks, we got California and Tennessee, Florida. I like Evanston and Chicago. Those are the Northwestern folks. So welcome, welcome. That chat function is there for you all to communicate with each other as attendees. And as you come up with some questions for Professor Menkel-Meadow, go ahead and click on the Q&A icon and put those in so that we can have a moderated Q&A discussion at the end. Oh, Art, I see some Arizona folks as well. All right, so that's a little bit about the Zoom functions. Let's see, just a note that everyone can see your posts in the chat, but in the Q&A, only the panelists will be able to see that you posted that Q&A, and you can even post it anonymously if you would like to. All right, to get us started, we've invited two of our star students from Northwestern to tell you just a little bit about the book that we are celebrating, its publication, as well as provide a brief synopsis of Professor Menkel-Meadow's featured article. So I'm going to ask that we go ahead and add to the spotlight Emily McConaughey and Anna Bush, two members of our negotiation competition team and TAs from our negotiation courses. Emily and Anna, do you want to join us?
Thank you, Professor Carrel. We are honored to welcome you to the book launch for Discussions in Dispute Resolution. This book is unique in that it identifies 16 of the most foundational writings in the ADR field and pairs each with 4 contemporary commentaries. During this month-long interview series, we are featuring the origin story behind one article in each of the 4 primary subfields highlighted in the book: negotiation, mediation, arbitration, and public policy. This week, we focus on public policy and look forward to hearing from Professor Carrie Menkel-Meadow, author of the featured article, Pursuing Settlement in an Adversary Culture, A Tale of Innovation Co-opted, or The Law of ADR.
Professor Menkel-Meadow writes this article at a time when ADR is shifting from an informal and innovative approach to one that is becoming institutionalized in what she calls co-opted. She describes the implications of this institutionalization and then identifies the questions that need to be asked to prevent ADR from becoming totally swallowed by the adversarial system. In her own commentary, which sits alongside of those professors, including Ellen Deason, Elaine Greenberg, and Jim Coben, she says in her own words, "Much of what I commented on then has only gotten worse. Today, we will get the unique opportunity to hear the origin story of this article and the motivations that led her to write it, and that might be motivating her still today."
Thank you so much, Anna and Emily. So now I'd like to introduce one of the editors of the book, Professor Art Hinshaw, who will be interviewing Professor Menkel-Meadow. Professor Art Hinshaw is a clinical professor of law, the John Boma Fellow in Alternative Dispute Resolution, and the founding director of the Lodestar Dispute Resolution Center at Arizona State University, Sandra Day O'Connor College of Law. Why do all of our schools have such long names? Art's research bridges ADR theory and practice and includes empirical studies on negotiation ethics and often calls for the professional regulation of the mediation field, which I totally agree, Art. In addition to his forthcoming publication, Discussions in Dispute Resolution, Professor Hinshaw is also the co-author of the casebook Dispute Resolution and Lawyers and has another forthcoming book, Negotiation and Lawyers, due out this summer. Please welcome Professor Art Hinshaw.
Allison, thank you so much. I can't thank you and Lynn Cohen and Lynn Riskin and everybody at Northwestern at the Negotiation and Mediation Center there for putting this together. Those of us who have been working on it from the beginning, which is almost 4 years ago, I was getting emotional just hearing you all talking about this. How exciting for us. Thank you so much. So it is my pleasure to be able to introduce Professor Carrie Menkel-Meadow. Professor Menkel-Meadow is a chancellor's professor at UC-Irvine, and she has been at Georgetown, she's been at UCLA, she's visited everywhere across the world, it seems like, all over the place. She's in high demand. She's written 200 articles, who knows how many books. I know that I have some of them on my bookshelf. You can see them kind of back there if you look really, really closely. And she's just done about everything that a person can do. Just for those of you who aren't a part of the academia of dispute resolution, let me put it this way, in a different way. Back in 2014, I, along with Sarah Cole and Andrea Schneider, we are contributors to the ADR prof blog called Indisputably. And there were other law prof blogs that were putting together, like, who are the 4 most important people in your field? You know, so you had the Mount Rushmore, they were calling it the Mount Rushmore. Mount Rushmore of contracts, Mount Rushmore of con law, all that kind of stuff. And I said, we should do this. So we did it. And of course, Carrie Menkel-Meadow was on it. So kudos to you. I think you're the only woman who made it on any of the lists. So kudos to you for that. And what is that you have?
This is a replica of Mount Rushmore, Art. It's a product of your poll. You'll see Roger Fisher, Carrie Menkel-Meadow, Frank Sander, and Len, if you're there in the audience, Len Riskin. This cute little thing was made by my biggest fan, my husband, right after your poll, Art. And so as I've told Art, it's adorable. It sits on my desk. And anytime I feel down, I take a look and know that we, the founders of the field, and there are others not on this little monument, still have a lot of work to do, but we've actually accomplished a lot. So that was adorable when you did it. Thank you.
Well, you're very welcome and most deserved. Well, then, speaking of work to do, let's get down to the work. It's my pleasure to do this interview. And this article is really a bit of a critique of dispute resolution in 1991, right? This is when it's starting to blow up and starting to become a big part of disputing in the United States. And I mean, your critique was not the first, right? We have Owen Fiss and Against Settlement. We have your friend Trina Grillo, process dangers and divorce mediation. Rick Abel in landlord-tenant court, and we also have Richard Delgado with the critical race theory angle on disputing and dispute resolution, but they're not on the Mount Rushmore of dispute resolution. So how did you come about this? How did you come to write it?
Great question. So It's interesting. I realized as you were speaking how many of those people were my colleagues. Rick Abel and Richard Delgado were both my colleagues at UCLA when they wrote their pieces after I had joined the faculty there and started teaching about this stuff. So we had some rather interesting intellectual conversations about the field. Rick studying informal justice all over the world, very concerned about the privatization of justice. And in Rick Abel's case, the argument that the state was going to increase power over people by having voluntary restorative justice programs, victim offender mediation, and more surveillance of the state. Delgado's argument, as some of you know, was that ADR was more likely to increase discrimination and unfairness because there wasn't a judge and an American flag and everything was going on in private. Trina was my dear friend and colleague, and indeed we had trained to be mediators together. And I just want to say, one thing I want to say about this is why I got interested in it is, except for Trina, everyone else on that list that you named was a pure academic, criticizing from outside. Using the words of Maria Volpe that have appeared in many publications, I've always been a pracademic, for those who don't know that word. Yes, I am an academic, I write a lot, I think a lot, but this article actually comes from my experience of being inside ADR. So the article, Pursuing Settlement in an Adversary System, came from the fact that by the time I wrote it, I was in all three of the categories that the article discusses. I was a conceptualizer. My first article, which I think is the other article in your book, Toward Another View of Legal Negotiation, was an attempt to reconfigure the way lawyers think about negotiation, to be problem solvers and not just to use the adversary system to beat the other side. And as a result of that article, I then it won the first CPR prize for scholarship in ADR. I was put on a number of panels to be a mediator, to be an arbitrator as well. So I conceptualized what I thought mediation should be like, what negotiation should be like. And then I was asked to be an implementer by being a consultant to the federal courts. I was a trainer for the Federal Judicial Center for many years, training judges and lawyers. And then in lots of local courts in California, Northern District, actually San Francisco, north of where I was at the time. And then just to fast forward, after I started doing a lot of mediation in the Wellington facility for asbestos and a lot of federal court and state court work, I was asked to be an evaluator. So I was hired by the Federal Judicial Center and a number of other places to evaluate how these programs were going. And I just want to say, I want to end when we're done. I want to end on an optimistic note because yes, the message is many of the things that I chronicle in that article have gotten worse. And as a conceptualizer, my hope had been really, really seriously to change Len is there, to change the intellectual map of the lawyer. And since I know some of you want me to speak to being a feminist and a woman, I will say, my negotiation article does not talk about interests like Getting to Yes does, but needs. From a feminist perspective, as Getting to Yes says, the interests are behind the positions. Well, Menkel-Meadow says the needs of people, human beings, are behind the interests. Interests are economistic, instrumental, and I include them too. It's additive. My world is additive, not substitutional or adversarial. And I really, a very, very ambitious goal. I really wanted to change the world and to change the way we think and the sensibility we have as we approach other people. So having done all three of those, I'll let you get a word in edgewise in a minute, Art.
Okay.
But having been in all of those roles, a conceptualizer, an implementer, and then an evaluator, I was really dismayed to see what was happening in the courts as it became institutionalized. But I want to say from inside, Abel, Fiss, and Delgado, whom I debated a lot in those days in various fora, they had very good academic arguments to make, but go back and look at those articles, everybody out there. There's very little empirical support for their claims.
And I guess that's where the rubber meets the road, right? Is the empirical support. But this idea of a conceptualizer, right? I mean, let me just make sure that I have this right. You taught one of the first pure negotiation class in the United States, is that right?
Third one. Despite the wonderful, I do something there every year, program at Harvard. Harvard was not the first. Roger Fisher was not the first. Undergraduate, yes, he did teach. Andrea's there. Andrea worked with Roger. Andrea Schneider worked with Roger both at the law school and undergraduate. But the first teachers of negotiation were J.J. White at Michigan, with Harry Edwards at Michigan, who later became a federal judge and a good friend of mine in Washington, and Cornelius Peck and Robert Fletcher at the University of Washington. All four of those gentlemen came to negotiation by being contracts, torts, and labor scholars. And so the first text, for those of you interested in the archaeology of our field or the genealogy of our field, there are some very early texts in negotiation. I do need to mention, we're talking about origins, my own. I was one of the first because the first generations of legal clinicians, of which I am a part, Gary Bello, who taught at USC when I was at UCLA and then ultimately went to Harvard. Gary Bello and B. Moulton wrote the first text for clinical teaching. And it's a wonderful book for those of you who haven't seen it on lawyering process. And that book has all of the lawyering skills with deep intellectual engagement with skills, which has been my life's work. We can't do skills without thinking about their conceptualization. So Gary Bello and B. Moulton, and B was from Arizona, Art, and many of us that taught students how to be lawyers started to teach with skills. So I started teaching negotiation at the University of Pennsylvania in my clinical course, lawyering skills, in 1975, I think it was. And so when I went to UCLA, I started to teach it as a separate course, a course of theory, because my negotiation article had drawn from many disciplines, political science, diplomacy, sociology, psychology, decision-making, and game theory. And so, yes, the big institutionalized programs now, Northwestern, Harvard, Georgetown had one when I was there, but never as big as Northwestern's or Harvard. There were lots of us that did individual, that's my phone ringing, I'll ignore it, lots of individual courses that preceded some of the big institutes that Hewlett Foundation and others funded. So yes, I wasn't the first. I won't claim that, but I was pretty early.
Well, I wanted to sort of up the conceptualizer portion there, just as part of the origin story. And so, you are somebody who's well known as, being one of the first in the field and doing these things. And yet here you are, this article comes out. What impact did the article have on both you, sort of how people treated you from within the field, without the field? And did the article have any impact going forward?
Great question. So I want to start with just a quick shout out to my dear deceased friend, Trina Brio. I assume all of you, I think it's also, is Trina's article in the book?
Yeah.
Too? Trina's
Yep,
another
article is here.
Trina's article, which was a critique of mediation from a feminist and woman's perspective in the Yale Law Journal. I think she suffered more from the ADR true believers being really upset with her. And I was too, and I was her good friend. And we had many conversations about what it was like to criticize from within. As I said, in that list of your first question of people who critique, Trina was the only one besides me who actually was a practitioner. And Trina had been a mediator in San Francisco. And then she herself had a divorce and went through compulsory California divorce mediation. And she shared with me how horrible an experience it was. So from Delgado's perspective and Trina's perspective, and then I was a smaller player in that debate, I think people took seriously the claim that some forms of ADR place the disempowered minorities, women, indigenous communities at a disadvantage with no judge there. That's Owen Fiss's argument, right. With no judge there. The impact that it had for me was that a lot of judges and the corporate lawyers who were members of CPR, Center for Public Resources, where I worked, spoke every year, I got pulled into the policy, this session's on public policy, I got pulled in by judges and courts and institutes to help create some efforts to evaluate. That's the impact it had. for me anyway. That is, I was asked to help develop some rigorous ways of trying to assess the claims of all of us. And the only one, since another little shout out if I can, I know she's long retired, but the best study was the Metro Court study, which some of you students have probably read in your studies of ADR. Michelle Herman at the University of New Mexico with a group of colleagues actually went and did, in my opinion, the most rigorous attempt to study all the arguments of Delgado, of Grillo, and me, to see if there was injustice and racial and gender disparities in adjudication and mediation. And they found some. And that study is in all my textbooks and in many of you, and in Art's and many of other people's textbooks. And I wish for the younger generation out there listening that somebody would get enough research money to continue to test the claims that we all made in those articles.
But you said that the impact on you from within the field was relatively light compared to Trina Grillo. I mean, was it really light? I mean, were people just like, oh, well, let's engage in this conversation, or were people like, how dare you Mount Rushmore Carrie Menkel-Meadow?
Well, ironically, I mean, like a lot of us, I have a practice on the side, meaning I mediate and I arbitrate. I'm on a lot of rosters. I get invited by a lot of parties. You know, this is a terrible thing to say, that in a sense, people saw me as being more neutral, right? I actually got chosen more as a third-party neutral after that article, certainly by the corporate lawyers that are at CPR, because to the extent I was seen after my negotiation article as your classic, you know, humanist, softy, former civil rights lawyer, plaintiff's lawyer, perhaps too biased to one side. That article established the fact that we ADR proponents, and I am still one, can also be self-critical of ourselves and of our field. So in an odd way for me, I already had tenure, I was already writing in other fields. I think it actually, in a very ironic way, Jim Coben, I hope you're there. My favorite article in the whole field is Disputing Irony. So we'll talk about that in a few moments. But I think there's something about having an ironic, you know, being a pracademic, having a critical view while you're practicing is very important. So and the only other thing I will say that I did want to mention, another shout out, one of my great mentors, I wouldn't be here today if it weren't for someone with whom I probably don't share many political views, Jim Henry, who is the head of CPR, a wonderful establishment corporate lawyer who really believed in this stuff. And so after I did that article, together with the Hewlett Foundation, Georgetown CPR and Hewlett Foundation funding asked me to chair a national commission to develop some standards of ethics and principles, both for individual practitioners, but for the institutions, JAMS, and all the AAA, all the institutions that were using, and the courts that were using these processes. So I was seen as someone that could help, you know, develop standards from a more, quote, neutral. Anyone who knows me knows I'm not neutral about very many things. And I don't believe in conventional neutrality in mediation either. I'll say something about that if you want me to. But I think the article, the impact was there was, in some quarters, a hope that some of the bad things that I described could be corrected by rules, standards, and regulation. I'm much more skeptical of that now, if you want to ask me about that. But that's,
well, let's start going that direction, right? So you, right, you've looked back at this piece. I presume that you haven't spent a lot of time like looking back at it because you're just so prolific and busy in so many different places, right? You wrote this or it was published in 1991, so you probably wrote it in 1990, mostly. Looking back on it 30 years later, approximately, are there any things about it that you're like, wow, I really thought that this idea was going to take off and it didn't, or I really thought that, you know, it was going to do this or that or the other thing? And are there any interesting stories about parts of the article, like some background stories about, was this part particularly difficult to write? Was this inspired by, you know, a conversation with somebody who, that might be an interesting story for us?
well, I think The real trigger for me, Jim Coben, again, another shout out to you. The big moment, the crystallizing moment for me was, here I am teaching about solving problems. The purpose of mediation is to be future oriented. Adjudication is important, as Lon Fuller taught us, when you have to have adjudication of the past. So I am teaching about the really existential, deep differences of these processes. And whenever I go to Boston or Cambridge, I go visit Lon Fuller's grave. Again, none of my mentors who I never met. I like to think of myself as, a second jurisprudent of the field. Lon Fuller was the first. So I'm teaching about these processes and what they might accomplish. And the trigger art really was a series of cases that are in that article. Strandell and Cincinnati Gas. All of a sudden, this is now so trite, but at the time I started thinking, this whole movement was to say, yes, law matters. Law is important in dispute resolution, but it's not the only thing that matters. And people's sense of justice for themselves or fairness for themselves may be just as important. And I think I was naive to think that we could talk about all these things and there wouldn't be any law about it. So I was then asked to comment, I think probably at CPR meetings, on the fact that some of these cases were litigating whether private mediation and summary jury trials and some of the early hybrids could be public, that someone could demand to go to a summary jury trial when the judge closed the door and allowed the lawyers to do a presentation for a fictive jury to deliberate and then come back with an advisory judgment of some kind. It wasn't a real judgment. And there was a push to publicize that which was private. Now, I just want to say, I've written a lot about how I don't believe in binarism, in brittle solutions, in a lot of dichotomies. So the notion of whether somebody should be public or private, those are pretty stark things. Will other people be allowed in to look at how your dispute's being resolved? And as a civil rights litigator, of course, I wanted court decisions to say you're wrong and you're right. But all of us who are mediators know that you can't settle a case unless some things are done in private. And I will say that publicly. We need secrecy sometimes and confidentiality. So the pull of those cases, you're going to laugh at it. The irony was, for all of you out there, if I can be at all inspirational to any of the younger generation, hang in there with stuff you believe in. My original article got rejected all over the place, my negotiation article, not this one, because there was literally no law in it. And the law review editors in 1882 or something, said there's no law in here. We can't publish this. And I am an interdisciplinary person, as some of you know, and my big push was to get all these other disciplines into the law school. So the irony, thank you, Jim Coben, is that while I'm trying to get the legal world to think more interdisciplinarily, law is relevant and important, but it's not the only thing. And there I am writing this article with my head buried in what was then the beginning, the launch of the law of ADR. And I had to start teaching it. And my casebook co-authors are here, I hope. Jean Sternlight, Andrea Schneider, Leila Love, and now Michael Moffitt having joined us. Our ADR casebook has cases in it, right? I never called it a casebook. I called it a learning book or a textbook or something. And I didn't want to call it a casebook, even though Walters Kluwer does. And if you look in that book, some of the sections are full of cases now. So the irony is, Menkel-Meadow, who wanted to say, yes, the law is important. We need rights. We need courts sometimes to declare what's right and wrong, but we need more than that. And so this article literally kept me up in it. I literally remember, you said I don't look at it, but I remember that I finished it at 3 o'clock in the morning, in that state of delirium that anyone who does anything, student papers or fancy academic articles or books in the middle of the night, you know what that's like. You finished it, you think this is great, and this is the middle of the night, it probably makes no sense. So I had a lot of people read it. And the other irony I will say, this is a tension for all of us that care about experiential learning and being different and being true to ourselves. The irony was, yes, some ADR true believers were very angry at me, but of course my academic colleagues just thought it was terrific because I could do the legal case crunching that is required of a law professor and I could be self-critical, and I wasn't just this, wifty, I am wifty 60s person. That's really what I really am. But I'm old enough now, I can say who I really am if it wasn't obvious to anyone who knows me. And so the piece is full of layers of irony for me. The law, I appreciate all three of my commentators, Elaine Greenberg, Ellen Deason, and Jim Coben. I love you all because in different ways you all said I was prescient, and I think I was.
Well, so let's get into what your commenters said. So you've name dropped Jim Coben 3 times at least that I've counted. So Jim, you win the prize. We'll have something delivered to your house in the next couple of weeks. Of course, that's a joke. So Jim was talking about sort of your Cassandra-like predictive abilities and how, like Cassandra, people weren't listening. So I was wondering, what's your thought of what's your response to Jim and his comment?
Oh, I love everything Jim writes. Because Jim, like me, I believe, no, seriously, I believe Jim was a true believer at the beginning. And if Layla Love's on the line, we had a wonderful conference at Cardozo a long time ago. I don't remember when that was. The years are getting fuzzy here. And Jim was there. And Jim began also to sound the warning bells of, for those of us who care about the human quality of mediation, and that's what brought me to it, the qualitative human connection that, I wrote about, the magic in a mediation room when people understand each other, or in my case, analytically, when they come up with a solution, that's different. So Jim, is out there now much more rigorously than me, policing, looking at what the courts are doing, and very troubled by 2 things. A, that the courts have to be involved, but B, that the court cases are observing some of what I said and what Jim is now others in the audience have documented this too. Coercion in mediation agreements, court programs pushing and requiring people to go to mediation in front of mediators who haven't had much training. And if I really want to get a word in about this, because my colleague Leila Love is very concerned about this too. In my part of California right now, almost all mediation is done without joint session. It's all shuttle diplomacy. And if you give me enough time, maybe the Q&A will let me get into it. I have thoughts about ODR. And the shuttle diplomacy stuff facilitates the coercion and the kinds of things that Jim and others of you are documenting. And I find it very troubling.
So then let's get to Elaine Greenberg's comment about, being a feminist theory and a masculine framework.
Well, I appreciate the comment, and it's been a tough issue for me. Again, I just want to say, anyone who knows me knows, I'm a very early feminist. I went to Barnard College. I was part of the beginning of the women's movement. I was in consciousness. Absolutely, my own consciousness is a very feminist one. But let it not be forgotten that aside, Mary Parker Follett, by the way, for me, is the founder of our field, a woman. But most of the writers that started us and teachers, I mentioned them, are men, okay? So yes, the adversary structure is very masculinist. Someone has to win, someone has to lose. All the metaphors are sports or war. Those of you who read my writing will notice that I have very deliberately used food metaphors, sometimes sewing and quilting. And, so I use more female woman type metaphors to describe healing, the sorts of things we're doing. But if you read any of my feminist works, it's a whole other bunch of my work outside of ADR, almost all of them end with the fact that I'm a feminist in search of humanist equality. I was raised in the religion, most of you haven't heard of it, but it was founded in Chicago, all you Northwestern people, Ethical Culture. Ethical culture was a religion, a secular humanist religion founded in the late 19th century. And it is one of those things criticized by the right as being a humanist secular religion. That's my feminism. It's my religion. I believe in equality. I believe that men and women bring equal concepts to the world. And so Elaine's right. It clearly informed what I was thinking. And I will say this, as a first generation in law school feminist, I'm very conscious of this. My feminist comments in a lot of my early work are all in the footnotes. And one of my more politicized feminist colleagues at UCLA, Christine Littleton, who's younger than me, pointed out to me that I was doing a classic female thing, which was apologizing for being a feminist. So in the early works, it's all in the footnotes, right? And for some of you in the audience who followed my feminist theory work, it's now not in the footnotes, and it stopped being in the footnotes at some point in the 80s or 90s. But it is interesting. So Elaine's commentary is very important about that. It's who I am. It's part of how these conceptions took place in my head. But I really want to shout out to all the men who are Art, you, oh my goodness, and Len and Roger Fisher and and all of the and JJ White, with whom I argued for years, because he's an old-fashioned adversarialist and believes that I'm wrong, that all of us are wrong on the empirics of how many cases can actually involve creating value or having tailored solutions.
And I think that's a fair criticism, right? And certainly something that it would be great for us, for somebody in this room to study. Last question, and then we're going to go to the Q&A. I want to get to Ellen Deason's comment, which is about the different values like efficiency, quality of justice, and the question of how much does law matter, which you've already touched on at least a little bit.
Yeah, well, basically, the two-sentence line here, Ellen's right. What I saw in the courts, what provoked me to write this article was my motivation was qualitative, quality, human problem solving. The courts, from the very beginning, when Chief Justice Berger started to say, is there a better way? He didn't mean better, I knew Warren Berger. He didn't mean better a little bit in a humanist way, but for him, it was docket clearing and efficiency. And those two values often conflict. And that's what happens in the institutionalization of ADR in some court programs. So that part's worse in the sense that now virtually every state court system and virtually all 94 federal districts require some form of a settlement conference, if that's all it is, a Rule 16 conference, or some form of ADR first. But its purpose is, let's get these people out of our courts. And if I might just say, ironically, one of my very close friends in Washington, Donna Steenstra, is the staff social scientist at the Federal Judicial Center. And when I was still in Washington, the FJC did a study of the use of court rooms, the rooms. And as you may all know, Congress authorizes money for judges, but also for buildings. And that study found that the courtrooms actually weren't being used that much after ADR. I was mediating in the DC circuit in jury boxes because the courtrooms were empty, and they actually had, this is an architecture question too, they hadn't built enough spaces for the kind of mediation that I like to do around a round table and interpersonally. So they sent us off to mediate in the middle of the adversary. How's that for a contrasting image, right? Trying to solve people's problems when they should be sitting in a circle, and we're actually sitting in a jury box where the chairs don't even face each other. And the function of that jury box is to pass judgment in a brittle on-off, yes-no way. I mean, the irony, thank you, Jim, again, the irony of the process and what you're doing inside a physical structure that's meant to do something else. So Ellen's right, and all of us know that. And so I know you want to get to the Q&A. I just want to say my other major concern for the field are the macro ethics of the field. Right. What is our field for? To create justice, to solve problems. And the conflict of these different values gets expressed that way. And for me, as a very fortunate now, as I look back on my weird career, older person who gets to do pretty much what she wants, both in terms of teaching and the cases that I take. For all of you that are students or young scholars out there, I've written a couple of pieces about the ethics in places where I have refused to do something. So as a dispute system designer, I was asked in Washington a lot to help major institutions create internal dispute resolution. And there are certain things I won't do. And that's why Ellen's critique speaks to me. I will not help design a program where the only purpose is efficiency and to get the cases processed faster. That's an important value. But for me, if the parties don't feel it's legitimate and serving their interests, I won't do it.
So I have a sort of a question for the future, right? If you're going to advise, students who are on this, young practitioners, maybe even young academics, what would you tell them are things that they need to be on the lookout for in this field?
Great question. So I think there are two big issues right now. And you should all think about it. I was fortunate enough to come in at the beginning and help found the modern version. Mediation's as old as China and Africa. We all know that. But I'm mediation 1.0. I'm a generalist. I was a civil litigator. I was a poverty lawyer. I've mediated. I mean, I used to say I wouldn't do an environmental dispute and I wouldn't do an IP dispute because those were science. And I was a word girl. I majored in literature and sociology, so I couldn't do numbers. I've now done everything. I mean, not everything, but every case type. And so for younger people, most of us say, go get yourself some great process expertise, but also get yourself some substantive expertise. Mediation 2.0 means be an IP lawyer, be an antitrust lawyer, be a discrimination lawyer, a labor lawyer, an employment lawyer, a commercial lawyer. And so there's a lot of advice to that. So your teachers will tell you that, not me. I mean, that's an easier way to get placed in a job. The beauty of good mediation is cross-pollination of ideas. I'm a conceptualizer. Some of the more creative agreements that I've presided over or helped facilitate in mediation were those in which we borrowed ideas from other disciplines and other fields of law. So I now feel proud and glad that I'm a dilettante or a generalist or someone who thinks she knows it all. That's what my husband says. And so that's some conflicting advice, you guys out there, whether to go deep into some field plus process expertise so you can advertise yourself as an IP arbitrator or mediator. And I would say still go horizontal. Learn as much as you can. And then the other thing, of course, which we didn't get to, so maybe you'll get to it in other interviews, is the role of what we're doing now, online dispute resolution. I began as a total skeptic. I believe in person-to-person. Touchy-feely is a good thing. Who doesn't want to be touched and felt, especially now that we're in COVID? It's a human thing to want to be in the room with people, but I now see some uses for it in some cases. So that's something you younger folks, I'm not particularly tech savvy. I'm getting there a little bit. So that's another way. It's a process expertise.
So you had teased us with some comments on neutrality during your remarks earlier, and it came up in the Q&A that somebody wanted you to expound on that. So here's a great opportunity.
Okay. So on this question, my mentor is my former colleague at UCLA, then at the National Institutes of Health, Howard Gadlin, known to some of you as a wonderful mediator and an ombuds person at NIH for many years. Howard used to, when he used to talk about neutrality, he used to say, neutrality is like a little halo above your head. It's the thing you aspire to, but no human being, especially anyone committed to any principles, is totally neutral about anything. What we aim for, and it's appropriate now with all of the discussion of implicit bias, but it's a word I've been using for 30 years. I will tell the parties, I'm not a neutral person. My husband's a Democratic political consultant. Anybody who looks me up will see that I'm associated with all kinds of progressive liberal causes. I'm not neutral about social justice in the state of the world. But in this dispute, I will try to be as unbiased toward you, the parties, or the issues as I can possibly be. And I will disclose and I will point out to you, both at the beginning and as we go along, anytime that I think I'm having a little, biasy twinge in what I'm doing, and I invite you to tell me if that's what I'm doing. Because I aim, this halo up here, I'm trying to be a good neutral person out here. That's the goal of mediation, and it's enshrined in all of our public values. But I think it's a human impossibility to be neutral. And I don't want to be neutral. Neutral in the sense of making the world a better place. So it's about being honest and disclosing and hoping the parties will understand that. And I'll just add that I was chosen in many employment cases over my lifetime with people fully knowing that I had been a Title VII plaintiff's lawyer and a civil rights lawyer. And it was often the defendants who would choose me because they would say, you know, if you're going to help mediate us, and we know you're sort of, you know, sympathetic probably to the claims of the other side, we trust in your legitimacy. And remember, mediators don't decide anything. So that's what I meant by that comment.
So I've heard that in employment cases as well, where defendants will say, we want somebody who the plaintiff, him or herself, will be able to trust and listen to. And we want somebody who has credibility with that individual more than we need that for that precise reason, right? In fact, that makes me think of Frankel and Stark wrote, that's Doug Frankel and Jim Stark wrote a piece several years ago talking about mediators being engaging in persuasion. And they got some pushback on that. People were like, what? We are neutral. And I was wondering if you had some thoughts on mediators as persuaders.
Don't get me started. So someone else I used to debate a lot, I don't think he is on the line, is Ken Feinberg, the special master par excellence. And I was in Washington and an advisor to him on the side when he was creating the 9/11 Victims Compensation Fund. Ken, we met, I don't know, again, early 80s, debating each other long before he took on a lot of the big cases. Ken is a persuader. Ken is a shuttle diplomat. Let me hear what the problems are. The first cases he got assigned were Willie, who's working for Ted Kennedy in the Senate, and was sent up to Massachusetts, where he was from, to settle some big cases. Listen to both sides, sort of using a little bit of a Roger Fisher one text procedure, hearing both of you, this is what I think a good deal would be, and now I'm going to go sell it, literally. I mean, and you know, and Ken used to say that a lot, that he was a salesman and a persuader. And so we would argue with each other publicly. I would say what you're doing is a valuable, valuable service. It's not mediation. So as you can imagine, very provocative. You know, audiences love those things. I truly believe that. I do believe it's a skill that mediators have. And Doug Frankel was my colleague at Penn for many years. So we're good friends. So Doug, if you're out there, you know, their book is wonderful. I think it's terrific. I don't agree with that. You know, if the parties want a persuader, they can hire a Ken. You know, the interesting thing about our field now is we have so many different ways of performing it that I hope that the lawyers and parties that are picking third-party neutrals become intelligent consumers and study the differences that we offer them. And I just want to say, I am primarily, having been trained that way, a facilitative mediator who likes to keep the parties in the room together as much as possible. But here's my two rules, folks. This is a good way to, if there's another Q&A, I'm sure there are other questions.
Okay, keep going.
Yeah, never say never and never say always. I'm writing another little book on negotiation, and that's one of my frontispiece epigraphs. Never say never and never say always, because our field is one of Art Hinshaw. Our field is of art, judgment, discretion, so I say, I don't say anymore, I will never caucus. That's ridiculous. There are circumstances in which the parties want to tell the mediator something very private. They don't want the other side to know. And something that they think either that should be known about them as people, or some facts about the situation that may not come out in public sessions. So, so I say, I used to say, as my dear colleague Leela used to say, never evaluate. That's not what we do. I've done tons of evaluative mediations by agreement of the parties. That's what the parties want. So party consent is another one of our core values, and that one still remains an important one for me. I won't do something unless the parties consent, unless it's immoral, unethical, or illegal, or violates Menkel-Meadow's ethical principles.
Great segue to the next question in the Q&A, by the way, which was about the idea of requiring people to do mediation. And the questioner basically said that the questioner was thinking that that was a bad idea to require it, but somebody had said to them, hey, I saw parties who wouldn't get in the same refuse, and they did it and they got it done and it worked and it was great. Why shouldn't we do that?
I love that question, because that was the first thing I changed my mind about as an academic, seriously. Again, very fortunate for me. after all my writing, I was put on the panel of the Wellington Asbestos Claims Facility. Harry Wellington was dean of Yale Law School and put together with a group of major lawyers, insurers, manufacturers, and plaintiffs' lawyers, the Wellington Claims Facility, and I was one of the first mediators in that program. So if you can imagine, I have a mediation with 25 lawyers with all the major insurance companies, AIG, Fireman's Fund, a whole bunch of other ones, and a bunch of companies that were in a dispute about the meaning of their insurance policies and whether in a merger and acquisition, warranties and proposals for mutual indemnification were actually going to apply. All right, so setting the stage, that case was big enough that there were Court of Appeals proceedings pending in 3 different Court of Appeals. Under the Wellington Agreement, in which the money was allocated by market share, these people had to go to mediation before they could continue their litigation. The Court of Appeals proceedings were stayed. Imagine, I'm still relatively young, long-haired, sort of like I look now after COVID. And what happened, we go to a hotel in Los Angeles, and there are 25 lawyers, and they sit there. We're here for one session because we're required to do that, required mediation. 2 years later, of monthly mediation sessions involving 25 lawyers, we settled the case. And as a teacher, I have to tell you, this was one of my proudest moments. That was in, I think, the late 80s. From that moment on, every one of those tough guy insurance lawyers, and they were all guys, I was the only girl in the room, would call me and say, I now have this case, can you recommend a mediator? As an educator, I don't know what it was that I did. I can't even recreate what I did. But to a man in that room, every one of them was persuaded that, not that they wouldn't go and litigate later if it didn't work, but every single one in that room learned that mediation was useful. And I tell you that story because it changed my mind. And so I think, and Italy now does this, I teach a lot in Italy, there is a mandatory you need to show up rule still. As some of you know, the Italian Constitutional Court struck down an earlier version of mandatory mediation, but there's a new one. And so I think I now believe that everybody should be required to show up somewhere and at least be told about the process. The problem, of course, is if they have bad mediators and no control, and they're going to have bad judges. They're going to have bad anything. There's always the problem of policing bad performance. But whoever asked that question, that was the first thing I changed my mind about. I now believe in mandatory referral, shall we say, to some mediative problem-solving type process.
All right, so since you said there was a first, that means there's a second. So what was the second thing you changed your mind about?
Well, I already told you about the caucusing stuff. That was in the middle there, where I used to prefer no caucus. And now it depends. I'm trained in sociology, right? What are the conditions of the case? What's the context of the matter? So I might, and I do all the time, go to caucus, at least partially. And then just to flip, or I mentioned the last one, which was ODR. I've written, some of you have seen it, short pieces. I was at The Hague a couple of years ago at a conference on ODR, and I wrote a short piece on how does a founder of ADR view ODR? And I have changed my mind about that. In part, I imagine some of you in the audience are participating in the mediation clinic online sessions that have been going on since COVID, run by Pepperdine. And I haven't been to all of them. I've been to a few of them. I am part of a senior mediators group, a bunch of us self-appointed, annoying people calling ourselves the founders of the field, that get together and discuss policy once a year. Now we've been doing it once a month since COVID. And when you talk to practicing mediators, I assume some of you are in the audience, some people have experienced a huge explosion of business and work because for some purposes, the breakout function there, which Colin Rule tells me he's responsible for those you know Colin Rule, that he, working with the Zoom people, had the breakout function put in. And here I am in California, Silicon Valley and other places are now working on all kinds of platforms to use technology to enhance different forms of dispute resolution. So for your younger folks out there, here's a place where you can put your conceptualization of what a good person-to-person interpersonal process might look like with some more online bells and whistles. And I I've become not a true believer, but absolutely there are places where it's appropriate. I will tell some of you that for the kind of touchy-feely person that I am, one of the issues with online stuff has been too much intimacy. I've gotten very close to some of my students last semester in doing my whole negotiation program online. And as you can see, we see each other in our bedrooms, in our studies. Our faces are closer to each other. Mm-hmm. So my skepticism about not being in the same room, every form of technology has pluses and minuses. It's all not all for the, never say never, never say always. It's all not for the good, it's not all for the bad. If we're going to have online dispute resolution, at least people can see each other. It's a lot better than telephone. So that's my latest exploration.
Well, and we get just a little bit of the nonverbal, right? I mean, on the phone, you can get the tone of voice, but now we can get at least some. We can't, obviously it's not as good, but still, I gotta say, I was like you. I was like, yeah, this will never work. In fact, I was asked to teach online courses. I was like, don't even ask me ever again. It's never gonna work. Just set it aside. And of course, here we are today. And plus, we have all these participants who probably wouldn't be around if we were doing this in person. There were a couple questions on Mead-Arb and asking what your thoughts were on Mead-Arb. Could you address that? I'm going to ask you to kind of keep it a little bit short because we're pushing the hour.
It's very easy, Art, because I can do this by pushing a new book. So there's a brand new published book called Comparative Dispute Resolution. It literally just came out. And my chapter is on hybrids. And it runs the whole Fullerian argument. Lon Fuller said these processes should never be combined.
Right.
And I always ask my students, what would Lon Fuller think as we look at these hybrids? So if you want to know my views on this topic, I have a whole chapter on it, and the book is wonderful. Comparative Dispute Resolution, edited by Maria Moscati, Michael Palmer, and Marion Roberts. They're all British scholars. It's an international book. There are chapters on all processes from many countries, and anyone who wants a copy of my chapter, send me an email. I have it electronically, and I can send you my chapter. And what do I think about it? I think process pluralism. Hybrids can be absolutely appropriate when appropriately used. And I disagree now. I used to totally agree with everything Lon Fuller said. When I said, well, what would Lon Fuller say? Well, he didn't live in our times.
No.
And times have changed and processes have to change. And I think I know you want us to stop, right? Because it's
right. And I mean, you can go, you're proof that you can go a long way following Lon Fuller. I mean, he is not anybody to be trifled with, that's for sure. Allison, I see that you're back on the screen. Are you trying to rein us in?
I am, and I just want to say thank you so much, Professor Menkel-Meadow and Professor Hinshaw, for doing this. There are claps happening. You can see it in the chat. People really appreciate all of your words of wisdom and sharing with us some insights into what that experience was like writing this foundational article. And I want to thank everyone for joining us today. We have a whole month series of these interviews. So we've got 3 more where we'll be featuring Professor Gene Sternlight next week, then Professor Bob Mnookin. And then on March 25th, we will end the series with Professor Len Riskin talking about that famous grid article. And because he's a colleague at Northwestern, we're also taking this opportunity to celebrate his impact and legacy on the field. So I hope you can join us for one or all of those. We're going to be putting into chat just the link to registration if you'd like to join us for those future sessions. We're placing into chat a link to the new book so that you can pre-order it with a discount on the publisher's website. And then we have a little giveaway, take away a commemorative bookmark that you can print out and add to your book once you receive it. So thank you all so much for joining us. Again, thank you, Professor Menkel-Meadow, Art, Sarah, Andrea, amazing work with this book, and look forward to continuing celebrating next week. Thank you all.
Thank you all. Thank you for listening.
Yes, thank you. And 30% off with the code that Allison has. 30% off. Got to make sure we say that.
And that's a
good discount.
Stay safe. Yeah. Stay safe, everyone.
Yeah, be well. Thank you so much for coming. We really enjoyed it. A lot of fun.
Thanks, everyone.